Good morning to all of you. Ethics class. Friends, in this video, I am giving you a synopsis of the Contempts of the Courts Act 1971. Basically, contempt means the offense of being disobedient or disrespectful to the court or its officers. It is what is called contempt. So, very simple act having only 23 sections. So, contempt is of two types according to section 2. Contempt is of two types, that is civil contempt and criminal contempt. So please remember, civil contempt means disobedience of the judgment, order, decree, writ or injunction order or any process of the court. So this is what is called civil contempt. So please remember, even though you give undertaking, if you make a false undertaking, if you don't observe the undertaking, it also amounts to civil contempt as stated in Noorani, babu, thanewala versus shetty 1990. Then we will go to the criminal contempt. Criminal contempt is disrespectful attitude. Publication of any matter or doing any act, please remember, which scandalizes or lowers the image of the authority of the court. Then, if anybody prejudices the court, if anybody interferes with the proceedings of the court, then definitely it is also contempt. And please remember, if anybody obstructs the administration of justice, అంటే కోర్టు మధ్యలో అడ్డం వచ్చి నువ్వెంత మాట్లాడితే obstructing the administration of justice, it is also criminal contempt. So to speak falsely or maliciously against judge, it is also contempt, criminal contempt. Section 3. So section 3 to almost section 6 we can say these are very important defenses or exceptions. Section 3 deals with innocent publication. Yes, it's not innocent publication or distribution, it is not contempt if it is innocent, but you have to prove that it is done due to innocence. Section 4 deals with fair and accurate reporting. Yes, definitely, truth always triumphs. Section 5, fair criticism, rolled up plea, honest opinion or bona fide comment. It is not contempt because in public interest you are commenting like this, but here remember, comment on the judgment, not on the judge. If it is judge, definitely you are liable for the so-called contempt. Then section 6 deals with, please remember, if any higher court is commenting anything against the subordinate judiciary, it is not contempt. ఈ జడ్జి పనికిమాలి వాడండి, మ్యాజిస్ట్రేట్ వీడంతా డబ్బులు తింటున్నాడు అన్నాడు అనుకోండి, ఇది నువ్వు కంటెంప్ట్ చేయడానికి లేదు. Section 10 deals with the power of the High Court to punish the contemners of the subordinate courts. So High Court ఎందుకంటే judges, normally this contempt action will be taken against both the judges and advocates, sometimes the government officers, and also normally not against the public. The normal I am telling. Section 11, High Courts can try only contempt cases. When you come to section 18, division bench, normally they take up the so-called contempt cases. And now we are going to discuss an important section, provision, section 12. It deals with the punishment. Simply remember, the punishment will be 6 months or 2,000 rupees fine. That's all, not more than that. And apology, it will be considered as number 1. Please remember, apology is the most important one. Please remember, if you tender apology, finish, no contempt. Section 14. Suppose before the High Court or before the Supreme Court, if any contemptuous action is taken, if any lawyer behaves in an unruly manner before the High Court, then he can be taken into custody. Please remember, trial can be conducted according to section 14. Right? Section 15. How they take cognizance of the criminal contempt. So normally, the contempt cases can be filed by Advocate General or the Attorney General. So any other person with the consent of the Advocate General, and court can suo motu take up the contempt case. You may be seeing in the press that Attorney General refused to give the permission. Section 16, contempt by judges or magistrates. They are also equal. If they do any contemptuous action, it will be taken up. Already I told you section 18, hearing of the contempt by benches. So normally, as every law, appeal procedure also there. Section 19 deals with appeals to a division bench, and ultimately the final appeal will be to the Supreme Court according to Section 19 Clause 3. Section 20 deals with the limitation period. Limitation to file the case, to file the contempt case, is only 1 year from the date of offence. Of course, after coming to know about the offence also, within 1 year you can file this. Section 23, Supreme Court can make rules regarding the contempt proceedings. So basically, this is within 5 minutes I have completed. It's not that easy, but you have to study the act, you have to read the act well, and then only you will be able to understand the essence of the same. You have to write answer question paper also, is it not? So please remember, in some cases, no doubt, contempt action is not necessary, or contempt action has been obsolete, OBSVLT అంటే ఏం జరగట్లేదు, but still contempt action has been taken. Prashant Bhushan case, recent case, is one of the best classic examples. So in the case of McLeod versus St.Aubyn 1899, so Lord Morris observed that committal for contempt has become obsolete in England, not necessary, because the courts are leaving it to the public opinion. అదవా పనిచేసాడు లేదని కోర్టుకే వదిలేస్తున్నారు. But it is not totally extinguished as per the case. Another case in Queen versus Gray 1900. So it clearly stated that this is not absolute in England. So please remember. So this is briefly regarding the Contempt of the Courts Act, and we will discuss the defenses, the punishments, different cases like Vinay Chandra Mishra, very important case, like Indri Arundhati Rai case. All these cases we are going to discuss in the next video. So wait for the next videos. Till such time, bye bye. Thank you.